Okay. My lords, my lady, may it please the court. This is the appeal against the order of the judge by which he dismissed the intervenor's claims in the court below. I intend no disrespect for parties by referring to their first names. I hope no one has any objection to that. I'm in the traditions of Mr. Ham, who represented my client below, who also referred to them by their first names.
Yes.
Now, the first question on this appeal is whether the two cash gifts made by Terrell to James on the 12th of July 2022 and 12th of August 2022 of 14.7 and 20 million US dollars respectively should be set aside in equity on the grounds of mistake under the principles in Pitt and Holt. And that was the principal basis upon which permission to appeal was granted by my Lord Justice Nugee in October last year. The second question is whether, if not, or in any event, we say, there is a common law restitutionary liability on grounds of failure of basis, falling on James by way of a personal liability to make restitution in respect of the gifts from Terrell. The judge said no in respect of both causes of action, and we say that he was wrong to do so. Now, I'll develop both elements of my case in some detail. Before doing so, it's important to set out at a high level in my submission what I say are the key factual features of the primary case, although they go to both parts of my case, namely whether or not there was a mistake by Terrell, which is relievable in equity. And I'll come to the authorities in more detail in due course, but the question ultimately is whether when Terrell made the gifts, she did so under a mistake of so serious a character as to render it unjust on the part of the donee, i.e. James, to retain the property given to him. So, briefly, as to the facts, Christina filed for divorce from James on the 15th of August 2017 and issued her financial remedy claim on the 29th of September 2017. The divorce proceedings were therefore issued in the middle of enormous ongoing overseas litigation in the De La Sala family. Since 2012, there had been hard-fought proceedings in Singapore between Terrell's late brother-in-law, Ernest, and companies which at the time were controlled by Christina James and Christina's brother, Edward. That Singapore litigation had arisen because in 2011, Ernest had procured that some 600 to 800 million US dollars be removed from the family's businesses to accounts controlled by him in Canada. Now, that first phase of that litigation ended in the Singapore Court of Appeal on the 22nd of March 2018, with the misapplied assets being returnable to the claimant companies, albeit impressed with a resulting trust in favour of two other De La Sala entities. Then the companies issued further proceedings to determine who the ultimate beneficial owners of those assets were, i.e. whether the equitable interest under that resulting trust notionally in favour of the other entities was in turn impressed with a further trust, and if so, in favour of whom. Those proceedings were settled on the 11th of September 2020 by a settlement deed under which my client's late husband, whom I shall call with no disrespect Bobby, because that's what he's called in the evidence, secured, so the judge held below, approximately, and this is very approximate, 600 million Australian dollars. Now, the judge found at paragraph 63, Roman 1 of the judgment, which is in the core bundle at page 130, that it was on the receipt of these monies, and I invite this court to focus very closely on the source of the funds. It was on the receipt of these monies that Bobby and Terrell decided to make gifts to persons whom the judge described as approved family members. The money in question, which is the subject matter of the gifts in this case, constituted the fruits of litigation which had lasted nearly a decade. And the reason I mention this, and it is a key point, is that the judge made the following findings on page 119 of the core bundle, in paragraph 20, about 17 lines down, in a sentence which begins, further after it emerged. And whether your lordships and your ladyship have it further after it emerged.
Not yet. How many lines?
Unfortunately, it's quite a long paragraph. It's either 21 lines from the bottom or 17 lines from the top.
It's just below the first hole punch.
Yeah. Further after it emerged.
Okay.
So what the judge found was that it emerged in 2018 and 2019, and again later, that the wife had approached Ernest, and I pause there to say, i.e. the enemy, to see if he was willing to pay her money to join on his side of the family dispute. It appears that he was not. And Bobby wrote on the 11th of March 2018, "You intend to cut a deal with Ernest. This is your ultimate betrayal of the whole family and utter hypocrisy on your part." In many written family communications thereafter, the wife was given the name Judas. And I would just ask the court in this context to turn up my client's evidence in the first supplemental bundle under tab 4 at page 44. That's supplemental bundle 1, tab 4, page 44. And look, please, at paragraph 19. So this is Terrell, the donor in this case. Over the years, the respondent has caused the family nothing but insufferable pain and anguish. Our Singapore lawyers in March 2018 informed us that the respondent was contacting Ernest Perez de la Sala, my late husband's brother, through his lawyers to try to settle directly with him and to try to do a deal for herself. This would have left her father with nothing.
I'm not sure it matters, but I haven't understood why that is so. The claims against Ernest were being brought by the companies. She didn't control the companies. Why would settling her dispute with Ernest have left her father with nothing?
Your lordship, of course, makes an interesting point in relation perhaps to the technicalities of the case. But the fact is that this was my client's perception.
Yeah, well, I understand that. That's why I said it may not make any difference. But
yes, it would have, and the point is that they would have lost control of the boards of the companies if she'd gone over to the other side.
But I thought she gave evidence saying that she was asked to vote with Ernest and said she wouldn't do that. I mean, it doesn't matter because the judge found, and what we're dealing with is the judge findings of fact.
Yes.
That for whatever reason there was a very, very serious
That's correct.
rift.
But the reason why I'm showing the court this evidence, my lord, it is not to make a forensic point about the history of the litigation. It's to show that it was my client's perception that she and her husband would not have had the very money that was gifted to James if Christina had got her way, and it would have left Bobby with nothing.
Does the judge accept that evidence, or because?
Well, he accepts that it was regarded as I've read that.
Yeah.
Yes. That it was, he accepted that it was regarded as a betrayal, and everyone called her Judas after that.
Yes. But I think one does need to be careful in a case like this to distinguish between what the evidence was before the judge and what the findings were.
Absolutely, my lord, and I'm going to try to do that. I was mindful of the interventions yesterday on that, and I fully encourage the court to pick me up if I stray on that topic. But anyway, what my client says is that my husband was fully aware of her duplicity and deeply saddened. So for almost the entire period of the divorce proceedings, Christina on the one hand and Terrell and Bobby on the other were estranged, and the judge found this as we've seen, and the word that was used in his findings on pages 118 to 119, paragraph 20, was the word hated. So he couldn't really have used stronger language than he did, and that was the finding. And by contrast, the judge held, I don't need to turn it up, that the family not only liked and got on well with the husband, they regarded him as having been absolutely loyal to them. As we heard yesterday, the judge found that a long time before Terrell made the gifts in question, James was aware that a substantial gift was going to be made. Possibly he was unaware of the precise amount by late 2020 and early 2021. And we also heard yesterday that in August 2021, gifts of 20 million, which were netted off against certain liabilities, were made to each of Christina's siblings, Bobby and Terrell. And the judge found, as I must accept, except the first of the gifts to James, which was made after Decree Absolute on the 12th of July 2022, was a postponement of the gifts made to Christina's siblings a year earlier, and that James similarly postponed accepting an offer of that same gift on the 17th of March 2022, after the financial remedies order had been approved for sealing, in both instances for, and this is a quotation from 63.2 on page 131, for fear that the wife would cause trouble when she found out about the gift. And I'll return to these events of March 2022 analytically in some detail in due course, but in the interests of chronological purity, I mention them now. Now, as I've said, the financial remedies order, which was a negotiated settlement approved by the district judge, was approved on the 4th of March, sealed on the 18th of March 2022, and Decree Absolute was entered on the 9th of June 2022. And I cannot shy from the fact that the judge rejected the evidence of the family witnesses. That's not something from which I shrink, and I will look at that in due course and address it in my learned friend's written arguments. So, as I said, Decree Absolute, 9th of June 2022, and on the 12th of July 2022, the first of the gifts was made, and the second on the 12th of August 2022. So let us now turn to the judgment to look at how Terrell's state of mind was presented to the judge after the evidence and what the judge found. So if we turn up, please, page 136 of the core bundle. In paragraph 80, at the very bottom of 136, we see this. Mr. Ham, who was counsel for Terrell below, put his case as follows. And I should just mention that this is taken from his written closing submissions, and the original text, for those who are interested, is in the second supplemental bundle under tab 24, pages 613 to 4. And so this is a quotation from the presentation after the evidence had closed. So Mr. Ham starts off accurately summarising the law, and I'm going to come to the law, as I say, presently, but I just draw the court's attention to the fact that in this quotation the judge had firmly in mind the concept of conscious risk-taking, because Mr. Ham, he quotes Mr. Ham's submission in relation to it in little 2 at the top of 137, unless the circumstances are such as to show that he or she deliberately ran the risk. So the judge knew about that concept. And what I want to show the court in particular in relation to my factual presentation are the 4 bullet points that Mr. Ham and his junior, Miss Houghton, made about two-thirds of the way down the page in the passage which begins, in short. In short, in order to establish mistake, Terrell must. I don't know whether your lordships and your ladyship have it. Yes.
Yes.
So 4 bullet points, 4 points. First point. So this was how the mistake was presented. She believed that the divorce proceedings were concluded so that any gifts she made to James could, not would, could not be claimed by Christina. Terrell confirmed this in cross-examination. Bullet point 2. That belief was a relevant cause of Terrell's decision to make the gifts to James. Again, this was confirmed in cross-examination. Terrell also emphasised James's cancer diagnosis as an important factor, but it was clear that Bob and Terrell were only thinking of making a gift after March 22 because they understood the divorce was concluded and Christina could not benefit. 3. That belief was mistaken. This will be established if Christina succeeds on her application to vary or set aside the consent order. And 4. The mistake was sufficiently grave to make it unconscionable for James to retain the gifts, etc. Now, if one then goes over the page to 138, remember he's had these 4 points put to him. The judge then says this: in my view, this claim certainly falls down at the point where I'm required to consider whether it would be unconscionable on the part of the donee to retain the property. That was Mr. Ham's 4th point. The judge does not reject Mr. Ham's points 1 to 3.
Doesn't expressly accept them either.
He does not, but it's important to look, therefore, at the context. Look at, my lords and my lady, look at Christina's counsel's closing submissions. In the second supplemental bundle, under tab 26 on page 653.
Sorry, can you go to the page again?
Yes, my lord. It is the second supplemental bundle, tab 26, page 653. Finding 20 in paragraph 20. W's family and H mistakenly believed that upon the financial remedy order being sealed, W could, same word, have no claim against H. Further down the page, 24, findings. So these are the findings which Mr. Walshaw was asking the court to make. W's mother and H mistakenly believed that upon the financial remedy order being sealed, W could have no claim against H. And then, my lords, what I would ask you to do in the same bundle is go back to tab 23 and look at page 550.
Sorry, you're going to have to...
I'm so sorry.
No, it's all right. Where?
Tab 23, same bundle.
Right.
Page 550, 550. So this is... I'm sorry, I'll wait for you, the court to have it. So this is where Mr. Ham is dealing with his first bullet point, if I can put it in those terms. And between A and B, the judge says, so a mistake here is, and then Mr. Ham, the mistake is, and the judge it says, her belief that once an order was made, there was no, and then Mr. Ham tries again, the mistake here, and then the judge says, chance of the wife getting her hands on any of the money. And then Mr. Ham says this, well, my learned friend this morning asked you to make finding 20. And then he quotes it. W's family and H mistakenly believed that upon the financial remedy order being sealed, W could have no claim against H, subject to the wrinkle about whether sealing is the cut-off point, and subject to the fact that we're only concerned with the donor who is on this analysis, Terrell. He was right about that, rather than Bob and Terrell, because Bob had died, he essentially says. That Terrell and James mistakenly believed that at the time of the gift being made, the wife could have no claim on it. So, says Mr. Ham, it does not seem to be an issue that there is a mistake. And then he goes on to another question, which I'm going to come back to later. And that was not dissented from, either by the judge in his judgment or by the learned friend. And one might just mention here that, of course, one has to remember that at first instance, Mr. Walshaw's primary task, number one on his agenda, was demonstrating that the motivation in relation to non-disclosure was not necessarily as it was being put forward by the family witnesses. So the mistake point kind of helped on that principal part of the wife's case below. But it was about the timing and the divorce concluding. It wasn't about some of the other things that were being said. And my learned friend yesterday showed you some of the cross-examination. Now, your lordships will recall, and your ladyship will recall, that in the judgment, it was said to the judge, and the judge didn't demur from this, that the cross-examination had established the mistake. The passage that your lordships and your ladyship was shown yesterday from Terrell's cross-examination was not the critical passage. The critical passage is in the first supplemental bundle, under tab 20 at page 292. That's the first supplemental bundle, tab 20 at page 292. And it's line 21. And it's line 21 which begins, Mr. Walshaw, we know you were being kept updated. Line 21. We know you were being kept updated about the divorce, were you not? Terrell says, of course. And we know, sorry, you know, that an open offer agreement had been reached, did you not? And then over the page, answer, I was only waiting for the final. Question, you were waiting for the final? And then the judge says, what do you mean by the final? She obviously wasn't referring to the FA Cup final. She says, answer, till he was free from Christina. And the judge says, till he was free from Christina, we were all waiting. And you knew that you could, notice that word again, not pay him, James, that money until the order was sealed, did you not? Answer, I could not give him any money in the same way I could not give Jake, a grandson by Christina, more money because Christina may have touched it. Question, that is the reason that you were so keen on the divorce being finalised, is it not? We all wanted the divorce finalised. And I pause here to say that evidence is why it is that the evidence to which you were taken yesterday, i.e. that Terrell said elsewhere that if James wanted to take Christina out for dinner or make a gift to him, that would be a matter for him, essentially. That is why that evidence is irrelevant, because it's a different concept from Christina herself touching it, with Christina being able to claim the money. That's the point.
Sorry, I'm not sure I understand.
Well, there's an obvious distinction between somebody being able themselves to get their hands on the money at their own volition and the person to whom you've given the money choosing to give it to that person.
Part of the question yesterday was court order.
Part of the question yesterday was
the piece of the evidence we were showing. Was there not a reference to court order in it?
Well, my Lord, I'd have to go back to you.
It was Mr. Todd that asked a question in cross-examination. What about if the court ordered him to give some money?
And she said that would be very unfortunate.
Very unfortunate.
That's correct. Yes.
So
Well, but that's just a statement of the obvious, isn't it? It would be very unfortunate if the court ordered him to do it. But what she's saying here is that I could not have given him the money if Christina may have touched it. And all she's saying there is that's very unfortunate. Is that if a court orders him to do it, he's going to have to do it. But it's not. I don't understand that to be inconsistent with this.
I'm sorry to interrupt you, but I don't understand your emphasis on the distinction between would and could. I could not have given him the money. There's nothing to inhibit her from giving him the money. There's nothing that makes it impossible for her to give him the money. Could not is being used there surely in the sense that I wouldn't have done it. Or it wouldn't be right for me to give him the money, or something along those lines.
Well, the could, yes, in this kind of context, that's right. I was emphasising the word could in the quotation from Mr. Ham's submission, which was that Terrell believed that the divorce proceedings were concluded so that any gifts she made to James could not be claimed by Christina, which is a question of law, essentially. And that was the way in which it was put. The case was not put on the basis that there wouldn't have been a mistake if James had wanted to give some of the money to Christina. And obviously if the money can't be got back and James is ordered to give it to Christina, well, that would be very unfortunate.
Well, that's why I put the point to Mr. Todd yesterday as to whether the case was that the money would have been given to Christina on the basis, it would have been given to James on the basis that Christina wouldn't be able to get her hands on that money.
Yes.
Rather than being able to benefit from it in some other way.
Well, my lady, that distinction doesn't affect the case as I'm putting it, because it's what your ladyship has said is completely consistent with how Mr. Ham presented the case below. So I can't, in the Court of Appeal, start interfering with that.
No.
That was how it was presented to the judge, and that was how it was presented on the cross-examination which the judge heard.
Sorry, can I just be clear about it? It was presented to the judge on the basis that the mistake was that Christina wouldn't be able to claim that money.
Correct.
Yes.
That's what. So that any gifts she made to James could not be claimed by Christina. I can't go behind that submission.
Yes. Thank you.
And so this all explains, when one understands what I've just taken the court to, and the way in which it was all presented, and the evidence as it came out, that explains why the judge jumps to the unconscionability requirement and appears on a true reading of the judgment in my submission to take as read the first 3 bullet points put to him by Mr. Ham, which are faithfully recorded in the judgment, without so much as a hint that the case before him did not disclose a mistake. It was dismissed on the basis of unconscionableness. Now,
I just wonder about the word certainly.
Yes.
Because it certainly falls down at that stage. That rather suggests I don't have to decide issues 1 to 3, because whatever the answer to issues 1 to 3, I'm not satisfied at 4. And in a sense, I'm not actually making any findings on 1 to 3.
I would be with your lordship on that if we didn't have this hinterland.
Yes, I see.
That I've just taken the court to. When one sees that Mr. Ham said, well, I've read Mr. Waterall's submissions, this doesn't seem to be an issue.
Yes.
And so one can't blame the judge. One can't blame this judge for saying, I'm going to look at the point which is the one that's troubled me.
Yes.
So, as I say, and this is coming back to my lady's question, this was a mistake of law, if one wants to be absolutely pure about it. If I wait until the end of the divorce, I can make a gift and the party to a marriage, and the other spouse can't make a claim against it. And it's really important that one is precise about the fact that that was a mistake of law as to a present state of affairs. My learned friend's references to this being a kind of a misprediction because it all depended on whether Christina actually did make a claim. That is about consequences of the mistake, and it goes to the gravity of the consequences of the mistake. If I can give the court an example. Suppose there are 2 drivers, both driving at 29 miles an hour down the road, both believe that they are in a 30-mile-an-hour zone. They both make the same mistake of law. One passes without incident, nothing happens, and that's that. The other one gets flashed by a speed camera, has 9 points on his licence, and loses his driving licence for totting. They both make the same mistake of law, but the consequences are different. The consequences for to one are grave, and the consequences to the other are not. But their mistake is the same. So when my learned friends say, oh, she's made a mistake about the possibility of something happening in the future, that's misprediction. No, what the possibility of things happening in the future and then those things coming to pass are the consequences of the mistake that she made as to a present state of affairs, i.e. that present state of affairs being a misunderstanding of English law, if one wants to be completely pure about it. So there can be no question that this was a case where there was a causative mistake. And as I've said, the real question on this appeal, and that's the basis on which the appeal was raised, as it should have been, was whether or not this was sufficiently serious, whether or not it's unconscionable for the donee to hang on to the gift. Now, what I would just say is just how serious this mistake was for Terrell. It wasn't just a mistake about money. One has to focus on the emotional context of this mistake and the judge's findings about the estrangement between mother and daughter, his use of the word hatred or hated and so on. This was a case of over my dead body will I make a gift from which there is any possibility of my daughter benefiting. Again, the source of the money is critical. Christina had tried to ally herself with those who were seeking to prevent Bobby and Terrell, as it was perceived, having the very money against which Christina now makes her restored matrimonial claims. Moreover, there was no sum of money beyond a de minimis sum which Terrell could give to James without Christina having a claim. We looked at the relevant passages yesterday, namely that the judge, in fact, there was much debate between the bench and counsel on this point yesterday, where the judge found that he, the judge, could not agree that the knowledge that the wife's parents' mother were planning to gift a substantial sum of money to the husband would have made no difference to the negotiations or the outcome of the case, and that it was a long way from being de minimis, the implication being if it was, it would have to be de minimis for it not to be problematic. And so for Terrell, this was the principle of the thing. Any possibility of Christina herself, by her claim, touching any money was unacceptable. That was why her error in believing, that's why her error was so serious. And there's a further feature which goes to the seriousness of the mistake and the scale of the prejudice to which it has exposed Terrell. This is because, as I will show, the court must assess the consequences, if your lordship, you should remember my analogy of the speed camera, the consequences to the claimant of her mistake when it comes to set aside the disposition, you assess the mistake, whether or not there was a mistake at the time that the mistake was made, but consequences is something which one looks at with the benefit of hindsight, as one must. It's impossible to know what the consequences are at the time that the mistake is made. That assessment can only take place, as it were, now. Here, the very monies which are in dispute in these proceedings are being claimed in other proceedings in New South Wales. Indeed, Christina herself challenges the validity of the very gifts which are in issue here in those proceedings. And Terrell is in substance alleged to face personal liability for equitable compensation. Terrell, of course, opposes those claims. I can't shrink from that. And indeed, she thinks they should be struck out. She's issued a strikeout application. Judgment is awaited. But she faces those claims.
Does that affect us?
Yes.
In what way?
Well, because in my submission, this court is obliged by law to look at the consequences to the donor of having made her mistake. So the consequences of the donor's mistake were that she put money into James's hands. I'm going to show you, Lordships, the pleadings, and your Lordship, the pleadings in a moment. But in essence, what is being said in New South Wales is that when Bobby died, 500 million Australian dollars, which were in his estate, were held on a constructive trust by Terrell in 4 shares for each of the 4 children.
Yes.
The gifts were made after Bobby's death. Terrell claims a 100% equitable interest in the monies which went to James.
Yes.
And she says that in default of getting her 125 million Australian dollars in totality, of which that 34 must form part, 34 million US dollars, she will sue Terrell in equitable compensation for
But
damage.
surely Christina would have made that claim whether Terrell disposed of the money to James or not.
That's true.
If Christina's claim is, I have an equitable interest in a stake of a quarter of the money that came to my father, she would be making that irrespective of any mistake made by Terrell.
Absolutely, my lady. But that's what makes Terrell's mistake so much more serious than it otherwise would have been. And I'll
Why?
show you.
It would be the same. The claim would be the same, the money would be the same. The only difference is that she would be facing a personal claim by her daughter for the return of the money. She'd still be making a claim against her for the return of the money, whether she parted with it or not.
That's a big difference. If I hold £100,000 for your ladyship, and then I mistakenly give 50,000 of that 100,000 to Mr. Todd, and your ladyship says, well, you can only give me 50,000, and so you've got to pay me out of your own pocket for the other 50. It's a serious consequence of my mistake that I have given that money to Mr. Todd. Particularly if your ladyship is the one who then comes to court to stop me getting it back, which is what has happened in this case. I think it may be useful to show your lordships and your ladyship the pleading.
Well, no, I'm still having difficulty with how it affects the question before us. The fact that the wife has brought proceedings in New South Wales saying this wasn't your money to give away in the first place has got nothing to do with the mistake that you rely on. It's a completely different.
It's a completely different cause of action.
Yes, but it's a completely different mistake. But because if she's right,
yes,
and it wasn't Terrell's money to give away, well, then that was a completely different mistake. That's
correct.
But that's not the one you rely on in these proceedings.
I completely agree with you, Lordship, about that.
So what we should be focusing, what the judge was focusing on, is what are the consequences of the mistake that was made in these, that was relied on at any rate, in these proceedings. And the consequences of the mistake relied on in these proceedings is that the divorce settlement can be reopened, and Christina says, I have a claim on that money. And James says, no, you don't, because in any event, it's not matrimonial money, and so on and so forth. And the consequences of that mistake are that some of the money which came from Terrell might end up with Christina.
Yes.
That is completely different
Yes.
from what's happening in New South Wales, which seems to me to have nothing to do with this case at all. And I have not yet understood why the fact that Christina in other proceedings is saying it wasn't your money to give away in the first place, has any impact on the mistake in this case and the consequences of the mistake in this case. Because Terrell wants James to have the money. Her whole complaint is, I gave it to James thinking that James would have the money.
Yes.
She's not saying I didn't mean to give it to James.
No, I agree. I agree with everything that your lordship's saying. And
And
can I just explain my submission and then
Yes.
I'll move on because I don't need this point. I mean,
No,
my
no,
submission, the
it
consequences of the mistake
it
are
doesn't seem
serious
to-
enough.
It doesn't seem to be a point that Mr. Ham relied on. It's not a point dealt with by the judge.
Oh, Mr. Ham showed the judge the New South Wales.
Yes,
proceeding.
but when, well, I mean, obviously, we've only got the summary
Yeah.
of his, but I didn't see it in that summary, the
No, that's
closing
true.
submissions, that it formed any part of.
Well,
This
I'll
part of the
show
case.
your lordship what Mr. Ham said because it comes straight after that passage, as I
Right.
recall. That's the correct recollection. If we look at the second supplemental bundle at page 613 to 4. The passage underneath mistake is what the judge quoted in paragraph 48. And then he goes on to say something about the constructive trust claim thereafter. It demonstrates Christina's motivations, etc., etc. But I'll just make my submission and I'll move on, my lord, and it's either correct or not. Your lordship's sceptical. But my submission is it depends on what the word consequences means. Because it is a consequence, it's unquestionably a consequence of the mistake that Terrell does not have that 34 million in her possession. That is unquestionably a consequence of the mistake.
Yes.
And what has happened is that the consequences of that mistake, which Mr. Ham referred to and which I fully maintain, have been aggravated by the fact that for different reasons, in different proceedings, there is now a proprietary claim to that money and personal claims against Terrell. It is in fact what is said by Christina is that James should simply hand the entire 34 million over to her, but clearly if it's untraceable or he can't do that, she maintains her equitable compensation claim against Terrell. And your lordship might say, it's almost like a remoteness point that your lordship is making. It's just not sufficiently connected with the mistake as a consequence. But it is
It's not a consequence of the mistake, it's a consequence of the payment.
It's a consequence of the payment. Perhaps that's the distinction.
It's got nothing to do with the mistake.
The mistake, except to the extent that but for the mistake, the payment wouldn't have been made. So it is, I mean, but for the mistake, Terrell wouldn't be in this position that she is now in, and in the degree of prejudice that she is in. So it's
Well, suppose she hadn't made the mistake. I mean, suppose she were right in her belief that once the order had been sealed, Christina couldn't claim the money. In other words, that she wasn't mistaken.
Yeah.
She still would have paid the money.
She still would have paid the money.
She'd still be facing the claim in New South Wales.
But
That's why I say
Yeah.
it's the consequence of the payment. It's not the consequence of the mistake. It's not. It's irrelevant to the fact she's facing. The fact she's facing a claim for 34 million personal liability for breach of trust in New South Wales,
25 million, yes, but yes.
or whatever it is,
Yeah.
in New South Wales, is. I was going to say divorced. It's probably the wrong word, but it's completely separate from whether she was right or not in her mistaken belief. That's just it doesn't flow from whether the belief is true.
I think
or
you've made your submission.
I've
So you're going to
I'm
make it
sorry.
and move on.
I'm going to
sorry.
move on.
I'm just
I'm going to move on.
conscious
It
of the
is
time.
part of the factual circumstances.
And you've made your point.
I've made my
I think.
I'm sorry.
No.
So,
It's my fault. I'll be very slow.
not at all. No, it was a fruitful discussion. And anyway, my lords and my ladies. So there we are. We've seen Mr. Ham's recitation of the law on page 137. I don't perceive there to be any dispute between the parties in relation to that recitation of the law on page 137 of the core bundle. He is there quoting Sir Terence Etherton, as he then was, when he was Chancellor of the High Court, in the case of Kennedy. And it's useful to take that summary, I can't improve on that summary of the law, as the principles to which we now must look. So the first one...
Do you want us to go to Kennedy? Or
we might as well just look at the judgment.
Okay.
But,
okay.
Or we can go to Kennedy, I don't mind. Kennedy's, we can turn it up. It's
Why not?
486 of the authorities bundle.
Which
is under tab 16
thank you.
in the second authorities bundle.
And you're going to this rather than pigeonhole because you think it's a...
It's a fair summary. I should forewarn the court that I'm going to dip into pigeonhole from time to time. But as a headline, this is a useful roadmap, the summary in Kennedy, of the principles. And I don't understand there to be any dispute about the principles between the parties. It's as to the application of the principles.
Right.
So the first one there, it's the little one in paragraph 36 on page 486.
Thank you.
Is that there must be a distinct mistake as distinguished from mere ignorance or inadvertence, or what unjust enrichment scholars might call a misprediction, relating to some possible future event. On the other hand, forgetfulness, inadvertence, or ignorance can lead to a false belief or assumption which the court will recognise as a legally relevant mistake. Accordingly, although mere ignorance, even if causative, is insufficient to found the cause of action, the court, in carrying out its task of finding the facts, should not shrink from drawing the inference of conscious belief or tacit assumption when there is evidence to support such an inference. I've already foreshadowed my submission that this was a distinct mistake about a prevailing point of law, and it simply is not the case that, as put in Moylan Friend Skeleton argument, that Terrell has litigated not over a consequence, but a possibility of a consequence. Her mistake was a mistake at the time that she made it. And whether or not the divorce proceedings have been reopened and what the consequences are of that to Terrell, those all go to questions of consequence and gravity. And there are lots of grave consequences, as I will show. I don't need the New South Wales proceedings. I want to make that very clear.
From 2020, there was an intention to make a gift.
From September, yes.
The initial instalment, can I say, of the gift, the amount was known in late 2020, early 21, according to the judge's finding. So there was an intention to make a gift from then.
Yes, my lord.
Was there any mistake at that point as to the intention to make a gift?
No, the mistake was made in July, on the 12th of July.
So it's purely a matter of timing of the making of the gift.
That's correct, my lord. That doesn't stop it being a serious mistake, because timing can matter, particularly in tax cases, for example.
And the mistake, I mean, you showed us that piece of evidence, and the evidence, speaking for myself, looking at the different parts, is not wholly clear. But just to be precise, are you saying that the mistake was that any gifts, that the gift could not be claimed by?
Yes, the mistake was that...
Yes?
The mistake was, my lord, that was the belief that the divorce proceedings were concluded meant that any gift she made to James could not be claimed by Christina. That was how it was submitted below, after the evidence and the cross-examination. that's just wrong. Because there are circumstances where a gift could be claimed or a claim could be made after the conclusion of divorce proceedings. Now, if one goes back to the language of Sir Terence hesitancy then was.
Well, it depends, doesn't it? If there was no prior knowledge on behalf of the husband as to the intention to make a gift, that's one situation. If the gift was made out of the blue, which I think is what the case was, after the proceedings had concluded, that's a different situation. So what type of situation did the donor have in mind?
It was very rudimentary, as I understand it, how it was put. It was simply that she believed that there were no circumstances whatsoever in which a claim could be made to the gift if it was made after the conclusion of the proceedings. And that was just a mistake. It would be a mistake in any situation. It just might not have any consequences in most situations.
I'm not quite sure how that fits in with the evidence we saw, as I say, yesterday. And you'll have to deal with this at some point.
Yes.
That the money once given was the husband's to do with as he wanted.
Well, that's just a description of a gift, my lord. I'm not dissenting from the fact that. I mean, we're going to look at that in some detail in relation to my failure of basis.
Okay, don't do it now then. It's just a nagging thought in my mind.
All gifts, all mistaken gifts, carry the intention that that the property will become that of the donee. But that doesn't mean that there aren't circumstances in which equity can relieve a mistaken gift. So, for example, you can make a gift to your trustees to apply on the terms of whatever the trusts are, but you might do so under a mistake as to the law of taxation, but for which mistake you wouldn't have made the gift. That doesn't mean to say that you don't intend the trustees to be able to apply the property according to the terms of the settlement.
So, I mean, does it all depend on what the outcome, if the order is set aside, is of the renewed financial remedy proceedings? It might be that the wife doesn't receive any part of it. And then what? Then it hasn't failed?
My lord, the consequences as they stand today is that the judge has found that these proceedings have been reopened.
Yes.
And that the wife is going to pursue her claims.
Yes.
And that is bad enough for Terrell.
Why? That's what I'm picking up what my Lord's just said. The way you have articulated the mistake, I think consistently with the way Mr. Ham put it below, that she wouldn't have given the money if she'd realised that any claim could be made to that money. Mm. Well, so far, the judge has not decided that the wife has any claim to that money. All he's decided so far is that the order can be set aside and there can be a further hearing. Indeed, he's given some provisional views which doesn't involve any part of that money going to the wife, as I understand it. If that's the outcome, then in what sense is Terrell's mistake of a serious character at all?
My lord, the first point is that one has to start with the claim that's actually being, or the open offer that is being made in relation to this money, which is in the judgment.
But the offer's not been accepted. An unaccepted offer is not worth
correct.
Anything,
that's her claim. And it would be, I mean, let's suppose a case, if we go to the taxation consequences cases, I mean, let's suppose that there is perceived to be a very serious taxation consequence in relation to making a gift. And then, as happened in, for example, the Deutsche Morgan Grenfell litigation, whatever, there is some very high court which says actually that tax was never payable. At the time that it's perceived that there is going to be a serious claim by the revenue authorities to the gift, that doesn't stop the donor being mistaken.
Well, it turns out he wasn't mistaken.
But what if he goes to court before the matter has gone all the way up to the top? I mean, it's possible that what the court could do is make some counter-restitutionary order, as Deputy Master Henderson did in Rog and Rog, to cater for that. But as matters stand, there is a serious claim being made to these gifts, which has been articulated in the amount of £13.92 million. And there is going to be a trial about that. So there are serious consequences for Terrell at the moment.
What were the consequences for Terrell at the moment of the wife, Christina, making a claim against James for more money? It's only if, as I understand it on your case, if any of that money is awarded to Christina, that Terrell's expectations are disappointed, isn't it?
Well, what she said is that she didn't want there to be a claim against it, so that has happened.
No, she said she didn't want Christina to touch anything.
That's true.
And if somebody brings a claim which
when I said she said, I meant through Mr. Ham.
Well,
Yes.
Well, touch was the word I think she used in the passage of
I could not give him any money in the same way I could not give Jake more money, because Christina may have touched it. And so I understand that Christina has made a claim against James for some of this money to be taken in as part of the reopened financial settlement. But suppose that claim fails. Where does that leave Terrell? It doesn't leave her any worse off, does it?
Well, so that if that claim fails after a trial, the very thing that she didn't want to happen has happened.
No, she hasn't touched any of it. She's brought a claim which failed. Well, it's a fact of life that sometimes people sue you when they don't have a cause of action, and sometimes people bring claims which fail. That doesn't mean. Well, maybe it does. Maybe you say that this is why one needs to be precise about what the mistake is. And why it's...
I mean, my lord, it just can't be right, can it, though, that if one makes a mistake of law, which results in the very consequence which one wanted to avoid, namely a claim being made, that one cannot go to equity to have that mistake relieved until the claims have been determined all the way through the courts, possibly all the way up to the Supreme Court. And that cannot be right, because it's always possible. If one takes the facts of example...
litigation.
I'm sorry, my lady?
I said it's what happened in the DMG litigation.
The Deutsche Morgan Grenfell litigation. Exactly. It's also what happened in... It's also similar to the facts of Roxburgh, which I might come to later, the Australian High Court case in restitution, where everybody was just proceeding on the basis that certain taxes were due. And then one day, the the High Court of Australia said that the taxes were completely unconstitutional. And so it can't be correct that if one makes a mistake, the subject matter of which mistake is, I will not make this money if there is going to be a claim against. I will not make this money over if there might be a claim against it. And that claim actually happens. And that claim is sized at 13.92 million. It can't be right that the claimant who has made the claimant donor cannot come to court at that point and say, I want to be relieved of the consequences of my mistake. Because it would never be possible to make a claim in those circumstances where there is any possibility of the claim failing, which must be the case in all mistakes, in respect of all mistakes of law, in relation to which the court will ultimately have to rule on the matter one way or the other.
So can we... Sorry. Go on.
I was going to say, I mean, very often the tax consequences are incontrovertible, and that was the case in Pittenholt. The settlement was a settlement for inheritance tax purposes, and nobody ever disputed that once the point had come to light. But this is I'm just looking at the way in which Mr. Ham put it, as recited in the judgment, and he puts it in slightly different ways at different points. At the first bullet point, any gift she made to James could not be claimed by Christina. And if you just looked at that, you might say, well, that's mistaken as soon as she makes a claim, or as soon as even as she could make a claim.
Yes.
But when you look down at the fourth bullet point, or third bullet point, Christina could not benefit. Fourth bullet point, which is the gravity of the mistake, it would be a serious matter for this court to effectively force Terrell to share a part of her wealth with her daughter. Now, that I understand on the way you're putting it, but that depends upon what happens.
May I put it the other way round? What happens if this court says, right, res judicata, mistake claim dismissed, and then the court at the end of the day does require Christina, James, to share £13.92 million of the gift, because it's not going to be able to come from anywhere else, with Christina.
What we're trying to identify is what your case is on what the mistake.
Yes.
And what my Lord's just pointing out is the mistake has been articulated in 3 different ways in the course of 10, 20, 15 lines of Mr. Ham's submissions. So we're just trying to get clarity as to what the... Maybe you wanted to show us... You were going to show us the pleadings, I know. Do you see what I'm just trying to... Because one is claimed, and that's what you were saying. You said gifts could not be claimed by. Then, as my Lord said, it's not benefit. And I know sometimes in the statements, in the pleadings, it's benefit. And then share, well, that is actually receiving some, sharing in it in some way. And if you're saying there must be a distinct, and you're showing us Kennedy to draw out of that a distinct mistake, I think what we're trying to grapple with is what is the distinct mistake that was being advanced. Is that...
Yes, well, my Lord, that's a fair question.
And I'm not asking you to answer that now. I'm just asking you to bear that in mind in the course of your submissions.
Yes.
To help clarify for us what the distinct mistake was, when, as my Lord's pointed out, even Mr. Ham seemed to identify it in a number of different ways.
That's a fair question, but I will preliminarily answer that question by saying that the way in which Mr. Ham puts it in the first bullet point is very similar to the way in which it was apparently conceded in the closing submissions of the wife, and that's which prompted Mr. Ham to say, so the mistake is not an issue. That is a preliminary answer to that question. I'm going to bear in.
The way I put it to Mr. Todd yesterday is that my understanding was that the case was, I'm not going to pay this money over to James if there's any prospect of Christina getting her hands on some or all of it. Is that fair?
Well, if that's a description of claim, then yes, my lady, that is fair. That's a sort of more...
That was the understanding.
Down to earth way of putting the word claim.
That was my understanding, just putting it in a very sort of bald way. Irrespective, it's the chance that she might get her hands on it that's the worry, not whether she actually did. It was that because that makes sense to me in the context of the divorce. The divorce makes it final, therefore there's no chance that Christina can get her hands on this money, therefore I'm safe to pay it to James.
And what she said in evidence in the passage which I took the court to is that everybody wanted the divorce to be finished, or words to that effect. Finalised. And what has happened, because of her mistake, is that the divorce is back on. And here we all are. And that is a serious consequence, so far as in my submission, which makes it a pigeonhole type mistake, or as described in Kennedy.
Sorry, we got rather diverted from the first point in Kennedy.
Sorry.
That's right. Well, I was going to move on to the second point in Kennedy.
Okay.
Which is this one, which Moylan and friends have got very excited about, which is that a mistake may still be a relevant mistake, even if it was due to carelessness on the part making the voluntary disposition. Well, it clearly was carelessness, I suppose, to some degree here. Unless the circumstances are such as to show that he or she deliberately ran the risk, or must be taken to have run the risk of being wrong. As I said, Mr. Ham put that squarely before the judge, and the judge, in fact, quoted those lines in his judgment. Now, Christina has tried to suggest that the judge actually found that there was conscious risk-taking in this case. And that's just not correct. Her theory turns on a passage to which you were taken yesterday, which is on page 131 of the judgment. In 63.2, at the top of the page, 131. And the top of 131 is quoting a letter from the 17th of March 2022
Yes.
from Bobby and the Intervenor offering the husband 20 million Australian
Yes.
dollars. And on the 18th of March 2022, the husband emails saying, thanks very much, I sent a photo, champagne were completed. And then, if one reads down, the husband told me that about a week later, so on around the 24th of March, he decided not to accept the gift. And then the judge says, no emails or messages he sent to explain his change of mind have been disclosed. Apparently there were emails, but they've been deleted by the husband. But it was clear from the oral evidence before me that the dominant motive at the time was a fear that the wife would cause trouble when she found out about the gift, i.e. seek to set aside the consent order, exactly what she has done. And that it was a question of postponing the gift to a time when the coast was clear, not cancelling it altogether. Now, the first point I would take from this is, without delving into any other materials, it's just blindingly clear on the face of that passage that the postponement was to when it was thought that the coast was clear. So whoever's state of mind the judge is referring to there, that is not a finding of conscious risk-taking. It is the exact opposite.
Can I just tell you, the coast was never going to be clear.
I know, my lord.
Because the gift had been promised. So this is complete pie in the sky.
I agree, my lord. It was a mistake.
No, it wasn't a mistake. It was a deliberate attempt to manipulate the situation by lying about the gift, so it didn't emerge that a gift had been promised. That was the mistake, to lie about it.
Well, my lord,
The gift was always going to be made, always. The lie was not disclosing that the gift was going to be made.
yes, the husband did not disclose the gift.
Yes. Well, then the parties tried to cover it up.
That came later.
They all
I'm going to
tried
have to deal with
hide
that
it.
in a different context.
So it's not where we can postpone it until the coast is clear. You can't undo what has been done. And I think that's a fundamental flaw on the part of your client and the husband in this case. It's looking at a different thing. It's looking at the making of the gift, not the fact that the gift was promised.
But the making of the gift is the transaction, my lord, which my client is applying to set aside.
I know, but it's this idea that if we postpone it long enough, the coast will be clear. The coast was never going to be clear because non-disclosure, there had been significant non-disclosure. That could have been found out 20 years later, and the case could be reopened.
My lord, I can't dissent from that proposition of matrimonial law. Of course, that's correct. But what we are focused on here is Terrell's state of mind when she decided in March and
Yes,
July.
the point I'm trying to make is the mistake was not making the gift. The mistake, if there was one, was promising to make the gift. That was what always meant that the coast was never going to be clear.
Well, it's possible that there were two mistakes. I mean, there's obviously, your lordship may well say, well, that was a mistake.
Well, it wasn't a mistake. It wasn't a mistake because it wasn't meant with any expectation of anything happening other than a gift going to be made.
But when the gift was made by Terrell, she believed that so long as she'd made it at the relevant time, there could be no claim against it. And that was a mistake in relation to the transaction which she entered into. And all I'm saying here, all I'm dealing with here, my lord, is whether the question of whether Terrell, whether there's a finding in the judgment, it's actually, it's almost a point of construction, as to whether Terrell engaged in conscious risk-taking, not in March 2022,
Right.
but in July 2022.
Your point is that even if you read that as Christina would have us read it, as the dominant motive being not just James's but also Terrell's, they agreed mutually to postpone it for this reason, the coast is clear reason. That's just a finding as to what happened in March. It's not a finding as to what happened in July.
Correct.
But Christina's point is, once you appreciate in March But it's not just the sealing on the order, because that had happened.
Mhm.
And everybody knew it had happened.
No, they didn't know that it had. They actually thought it had happened earlier. So I think for those, yes, I can accept that. Yes.
Okay.
Yeah.
They believed that it happened. Once you find that on the 24th of March, or whenever it is, there's a postponement because you're still worried that the coast is not clear, then you know that there are risks involved in making gifts after the date on which the order is sealed. So it cannot be right that you think that sealing the order is necessarily the end of any problem. That I think is the case that is made against you.
That is the case that's made against me, and it requires, as your lordship says, as its first point, for the dominant motive which is found there to be Terrell's motive as well as
James. And I thought your submission was, we don't need to resolve that because even if it is Terrell's, it doesn't help.
That was my first submission. Yes. I mean, because of the words "the coast is clear." So what that must mean, following the logic of your lordship's analysis, or rather Moylan and Friends' analysis to its conclusion, if we are talking about a single mind here, which everybody has, is that when Terrell made the gift, she believed the coast was clear. That is the logic of the mutual mind, if I can put it in those terms. And that is not consistent with a conscious risk-taking case.
I'm a bit more concerned about the fact that trying to square a belief that the coast is clear with the motivation for the cover-up. Because there's no point in, there wouldn't be any reason to cover it up if you didn't think there was a risk. That's a much more basic point, which I think goes right to the root of this alleged mistake. I'm trying very hard to square the idea that there are findings that your client and the husband were party to a decision to consciously keep this gift out of the cognizance of the court if they actually thought that there was no risk that Christina might get her hands on it.
Well, my lady, the financial remedy proceedings were reopened in 2023. So we're talking here about what was going through people's minds in 2022. So it wouldn't be fair in my submission to draw an inference from an approach to the litigation a year and a half earlier as to what was going through people's minds in 2022. And the judge doesn't draw that inference. It's just not there on the judgment, in my humble submission. But Malort did put his rightly challenged me in saying that one has to try to work out whose states of mind the judge was referring to. And in order to do that, one has to have a look at the cross-examination again. So if we look in the first supplemental bundle under tab 13 at page 305.
This is still dealing with the risk point.
Yes, this is still dealing with the risk point.
Sorry, can you give me the page again?
305.
Thank you.
Line 23 on page 305.
Sorry, this is cross-examination of
Terrell.
Right.
Line 23.
Yes.
We then know that James defers the money, do we not? Yes, that is fine, says Terrell, because he is worried about Christina's reaction. I do not know why. He just says it is fine. He just said, what? I do not remember exactly, but it's not a problem. He wanted to defer it. That is his decision. So when you offered 20 million, he came back to you and said, well, what was the broad message that he said to you about that? Asks the judge. Not at the moment. Not at the moment. And the payment was to be deferred. So from that time onwards, would it be reasonable to say you were just waiting for him to tell you when the convenient moment would have arrived? Why is that right? It was not important to me to worry about it. He could just let me know when he wanted it. And the judge was not invited. Well, in fact, the first point is it was not suggested that she was lying about that. And secondly, the judge was not invited to make a finding that she was lying about that, and the judge did not make a finding that she was lying about it. But what the judge did do, which is a fair point, is that he did reject her evidence that it was to do with that it was cancer that activated the deferral. But he didn't reject her evidence that she didn't know.
Didn't know.
Why James had asked for the deferral.
Right.
Correct. So it's a stretch to say that there's a finding in this judgment that Terrell engaged in conscious risk-taking because of the events of March 2022. But it's worse than that, because what we do know as being definitely true is that Terrell did not make the gift until after decree absolute. Now, whether or not that mattered as a matter of matrimonial law is neither here nor there. And that key event was not explored adequately or at all from a conscious risk-taking perspective with her. So to make good this case, one has to rewind to the trial. In fact, it would have to be retried if one was interested in it. Because Christina's counsel would have needed to put to Terrell, which he didn't, that she believed in the period around 17th of March that there was a risk that Christina could reopen the divorce proceedings even after the consent order if she made the gifts. 2, that she still believed that there remained a risk of that happening after decree absolute on the 9th of June 2022. 3, that she consciously took that risk when she made the gifts in July and August 2022 after decree absolute. None of that was put to her, not in that way. It wasn't suggested to her that you knew and you took a risk. And the judge was told by Mr. Ham, as I've already shown the court, that there is this conscious risk-taking principle, and he doesn't say anything about it at all. And the reason why he doesn't say anything about it at all is it was just not before the court. And therefore, quite properly, having not put those questions to the witness, my learned friend, quite properly, Mr. Walsh, did not invite the judge to make any findings about conscious risk-taking, and the judge didn't make them. And that's why we say that if this point is to be run in a court of appeal, which even with a respondent's notice it should not, because the point wasn't taken below, there should at least be a respondent's notice saying that the court should have decided the point, the judge's decision should be upheld for different reasons. And there isn't one. But even if the court were minded to entertain this argument and is against me on all of those points which I've just made, the point is still not good enough, because even Christina's counsel do not feel able to say that the risk as perceived in March 2022 maintained its potency until July 2022. In their skeleton argument, which is in the core bundle at page 158, para 14, one sees 2 lines from the bottom. Yes, it's actually probably a good idea to read that whole penultimate sentence, which refers back to the realisation of the set-aside application. This is no doubt because W's mother appreciates that it illustrates that she and her husband were not operating under any causative mistake, and when they later made the gift, they recognised that there was a risk of W benefiting from the gift, but they considered the prospect of this happening to be much diminished. Now, what we then don't get...
Sorry, where is that?
I'm sorry, that's paragraph 14, penultimate sentence.
I see. Thank you.
So what they shrink from saying there is the degree to which there is still a perceived risk, and that really matters because there is a distinction on the authorities, which I can turn up, but I don't imagine that it's going to be in dispute. I mean, I can show your lordship to the passage, between a mere doubt and conscious risk-taking. It's probably worth just showing the court this briefly.
Sure.
It's in the first authorities bundle, under tab 10, page 222. And this is the decision. I'll just let your lordships and lordship find it.
Yes.
This is the decision which my lady just mentioned, DMG, I think your ladyship called it, Deutsche Morgan Grenfell. I don't know whether I'm right. That is the decision you're referring to, I think.
Yeah, but don't forget it's been reversed.
It has been reversed, but this passage was followed in Pippin Hall. So we can have a look at it. The relevant bit is in paragraph 27, 5 lines down. I would not regard the fact that the person making the payment had doubts about his liability as conclusive of the question of whether he took the risk, particularly if the existence of these doubts was unknown to the receiving party. And that was in the context of the case, which was about a tax mistake. If one goes up to paragraph 26, this is Lord Hoffman again, third line down in paragraph 26, contestants in quiz shows may have doubts about the answer. It sounds like Haydn, but then it may be Mozart. But if they then give the wrong answer, they have made a mistake. So a mere doubt is not good enough for conscious risk-taking. And so it's very unsatisfactory. This case should just be rejected on the facts. But it's very unsatisfactory that it should be said, well, the risk was much diminished. But we don't know the degree to which it's even said that the risk was diminished. And there's no exploration of it in the judgment at all. If it was diminished to the point where the coast was thought to be clear, then it can't have been more than a mere theoretical possibility or a doubt. That's all I say about that. So, gravity...
Sorry, I'm not quite sure. I'm just looking at what Lord Hoffman is saying. I'm not quite sure what you say this passage in DMG is authority for. It's my fault. Say that again.
I'll say it again. It is simply... this passage, and it's probably, I probably should say this, my lady made a very fair point that this judgment has been departed from by a subsequent Supreme Court case.
Not on this point.
Not on this point. All I'm saying
is that one of the FII cases?
Yes, the one in the Supreme Court.
Well, there are several, I think.
Yes, well, and I believe that both my lord and my lady have been involved in some of them. But the point I was making is that there is a distinction. There is a distinction between harbouring a mere doubt and taking a risk, which means that one hasn't made a mistake.
Distinction between doubt and consciously taking a risk.
Yes.
Is that just a distinction of degree?
Yes. And my simple point, it's not my most important point, which is why I don't want to get stuck on it,
yes.
Because there are so many reasons why the conscious risk-taking position is a chimera.
Well, you say it wasn't pleaded.
It wasn't argued.
It wasn't put.
There's no respondent's notice. There's nothing.
All that.
Yeah. No findings.
But those are all, as it were, procedural objections to the point. That doesn't diminish their potency, but I mean, on the substance of the point, you say, even if it were the case that they still harboured doubts, or Terrell still harboured doubts in July, that doesn't equate.
Doesn't equate to conscious risk-taking.
Equate to conscious risk-taking so as to take it out of pigeonhole tax.
That's right. But that's my fallback position.
That's your fallback.
That's
your answer on the substance.
If the court is against me on how to read the judgment,
yes.
If the court doesn't accept that well, and the procedural points actually do matter from an evidential.
No, I'm not saying they don't matter. I'm not saying
they're
they
not
don't matter.
just procedural points.
I'm
it
just
matters
saying
to the evidence. The question wasn't put to the witness. So
No.
Yes.
That wasn't to say they didn't matter. It's that they're a different type of objection.
Yes.
That's all it is.
Well, it's substantive to the extent that the witness didn't give any viva voce evidence on the question of whether or not she was consciously taking a risk.
Because she wasn't asked.
So, the real meat of it, gravity and unconscionableness. That's the basis upon which the judge at least explicitly dismissed the case. And I'm going to take on board some of the points raised from the bench this morning.
Thank you. How are we doing time-wise?
An hour and 5 minutes before the short adjournment.
Yes.
So I will try to finish by the short adjournment.
Okay, thank you.
It depends a bit.
Yeah, of course it does.
And also, yes. So, gravity and unconscionableness. Let's go back to the summary in Kennedy, page 487. It's subparagraphs 3 and 4 on page 487.
Yes.
The causative mistake must be sufficiently grave as to make it unconscionable on the part of the donee to retain the property. That test will normally be satisfied only when there is a mistake either as to the legal character or nature of a transaction, or as to some matter of fact or law which is basic to the transaction. The gravity of the mistake must be assessed by a close examination of the facts, including the circumstances of the mistake and its consequences for the person who made the vitiated disposition. And then 4, the injustice or unfairness or unconscionableness of leaving a mistaken disposition uncorrected must be evaluated objectively, but with an intense focus on the facts of the particular case. The court must consider in the round the existence of a distinct mistake, its degree of centrality to the transaction in question, and the seriousness of its consequences, and make an evaluative judgment, in order discretion, whether it would be unconscionable or unjust to leave the mistake uncorrected. So the gravity of the mistake, my lords, and my lady, we have already looked at the powerful emotional context in which Terrell was determined not to make a gift to James, in respect of which there was any possibility of Christina making a claim. She wanted the divorce finished. The divorce has been reopened because she made a gift. And this is something she cares about very deeply.
I understand that. I'm sorry to repeat the point. You do have to deal with the fact that the gift was promised in 2021, and I'm not aware of any evidence as to the any limitation about the promising the gift. You're focusing on the making of the gift.
Yes, ma'am.
But as I've already said, the promising of the gift and the identification of the amount was in and of itself a sufficient non-disclosure to create what has happened. In other words, a set-aside application and a successful set-aside application. So that you have to deal with that when you're looking at gravity of the mistake and identifying precisely what the mistake is. Because I'm not saying it was a mistake, but in your language, it was a mistake to promise it.
Well, no, I don't say that it was a mistake to promise it, although, I mean, that it was a mistake to promise it, but it was but that she would not have made the gift if there was any chance of the wife making a claim to it. So it was a mistake to promise it, but it was also a mistake to make it, because as my lady has correctly picked Mr. Todd and me up on, this is about Terrell's money, which had come from the litigation, which Bobby and Terrell never wanted there to be any claim against by Christina, ending up the subject matter of claims by Christina. So the making of the promise might have been a terrible mistake, but it was the handing over of the money that was the relevant mistake for these purposes, and that was the transaction.
If I can put my Lord's point, or what I think my Lord's point is, in a slightly different way. Suppose everything had happened in the same way up until March 22, and at that point she'd taken advice from an English matrimonial lawyer who said, well, you can't just assume that once you've got the order sealed, it's safe to make it. In fact, because you've already promised the money to James, Christina is today able to set this aside because James has a financial resource which he deliberately did not disclose. And so actually it doesn't make any difference now whether you hand the money over or not. It's still possible for Christina to reopen the settlement because James didn't disclose that he was going to receive, and he knew he was going to receive, $20 million. And so the making of the payment has no causative consequences by itself at all, over and above those, I think this is my Lord's point, that have already been caused by her decision, communicated to James, to pay him the same as Christina's siblings, and her and James failing and not only failing, but as we saw yesterday, misleading through his counsel, the district judge, when asked to approve the consent order by suggesting, which he knew to be untrue on the judge's findings, that the parents, he hoped, would make gifts equally to him and the wife. Just plain lie. Well, not a lie by counsel, obviously, but just plainly untrue. So, in those circumstances, why does the actual making of the gift have any consequences at all?
It has consequences to Terrell, because it is only the making of the gift which is going to expose the gift to claims.
No. As I understand,
No,
the law, if it's a resource which is available to the husband, it
Yes.
can be taken account of whether it's actually been handed over yet or not.
That's absolutely correct as a matrimonial law, my lord, I agree. But what Terrell cares about, and this is where my lady was going yesterday with her questions of Mr. Todd, is that Terrell does not want this money to be the subject of the claims. It may be in a way that it can actually be touched. That was her evidence. So, so let's suppose, as you write, I take that hypothesis. She goes to a matrimonial lawyer. She goes to Mr. Todd or Mr. Walsh. She goes to the very best, and she said, and they say, you can't. You've blown it, basically.
Yeah.
You've told him that he's going to get the money. He's got to disclose that now. He can't not disclose it. The divorce is getting reopened, and she gets, that's obviously very upsetting. But if she then doesn't make the gift, what will happen then is that the divorce will be reopened, and there'll obviously have to be evidence about the likelihood of her making the gift in the future. But it's only if she makes the payment there is going to be any claim to that money which she does not want to be claimed. It's true that the divorce might get reopened on the basis of the divorce might get financial remedy proceedings, I must be precise about this, might be reopened on the basis of a Thomas and Thomas type resource argument, like Charman and Charman, your lordship's case. But that is not, but so far as Terrell is concerned, and it was put on this basis by, as I say, by Mr. Ham, and one who've seen the evidence, that she did not want there to be a claim to the money, and she could have stopped that, even if there'd been a trial about whether or not it was a Charman type resource or a Thomas or Brown and Brown type resource. There could have been a trial about that, but she didn't want this money, which had been hard fought and won in litigation, and which her husband had gone to his grave not wanting his daughter to be able to touch, literally being, as it were, the subject matter of this 13.92 million claim, as it's turned out to be. And so there is a distinction, my lord, I'm suggesting my Lord Justice Moylan, between almost to call it a mistake or whatever one wants to call it, as to making the promise and making the payment. They're two distinct things. Making the promise at the very least meant there might be a resource type claim. Yep. Making the payment meant that there could be a section 24(1)(a) or other such claim to the property itself. And it was that which she cared about, and that's why I started my presentation this morning with the source of the money. There was something important about this money. My client's perception was that this money was something which had been hard fought and which her daughter had tried to stop the family from getting. So that's why it was a grave mistake, that there should now be a claim on foot, except it's unresolved, which targets that money by way of a sharing claim sized at £13.92 million. And I do preannate the fact that these gifts were made less than a week after Terrell's husband died. And I don't have time, looking at the clock, to take your lordship to the evidence of how deeply emotional this all was for my client. I'm sure that can be taken as read.
I haven't understood the significance of it being shortly after Bobby's death, I'm sorry.
Well, because Terrell makes these gifts, Bobby goes to his grave not wishing that the money is not going to go in any way to Christina. And Terrell then blunders by making this mistake and paying it to James, which exposes the money to a claim by Christina. And that is an emotional context which the court can take into account in terms of the mental seriousness of the mistake to the donor.
I understand that the death of her long-standing husband may have been an emotional period for her, but I haven't understood why that makes the mistake any different, whether she makes it a week after his death or 2 years after his death. I'm being very slow, I'm sorry.
Well, because it wasn't a mistake that they, as it were, they sat down together and made. So, I mean, he dies thinking, I don't want this money to go to Christina.
So he hasn't made a mistake.
So he hasn't made the mistake. I mean, he probably, he did write, he is the co-signatory or co-named signatory of the letter of the 5th of July, we know that. But, whatever authority he gave for these payments, as your lordship will know, was revoked by his death. And therefore, it is Terrell's mistake.
Well, it's no longer his money once he's dead. I mean, if one's being...
Yes, that's true, but there is an emotional context here.
Well, yes. Okay.
Yes. And that is not something, that's not, I mean, it is still important. So, and I say, as I said already, I've already just repeated myself, we have to focus on the source of the money, we have to focus on how the family got this money, and what it meant, and how strong the feelings were about the fact that, well, if it's going to go to anyone, it's not going to go to Christina. And it's important to stress, and this is something which Mr. Ham made much of, but he was absolutely right to do so, that Terrell and Bobby didn't live in a forced heirship jurisdiction. They've got no legal obligation, subject to 75 Act type claims, to give money to their children.
Well, there is a succession claim.
There is a succession claim in New South Wales.
Where did they live? Where were they domiciled?
They were in New South Wales. Yes, New South Wales.
Yeah, so they're domiciled, and as you say, it's a common law jurisdiction.
Yeah, it's not a forced heirship jurisdiction. There's no repugnance in the law, but we have to presume that the law is the same as English law, because there's no expert evidence of foreign law. There's nothing repugnant to the law of England, which says, I'm not going to give money, either inter vivos or by will, to my daughter.
No, but... Yeah.
And that has to be borne in mind. The consequence for Terrell, if we're going to talk about the seriousness of the consequences, is that she's ended up exposing money which she and her late husband never wished to be claimable in any way, to Christina doing the very thing that her husband went to her grave not wanting to happen, and which Christina did not want to happen. She didn't want Christina to make trouble, and that's exactly what has happened. And that is, to go back to my lord's piquant questioning of me about the significance of the New South Wales claims, that point is a direct consequence of the mistake. Now, as to the unfairness or unconscionableness of leaving the mistake uncorrected, let us now look at Pittenholt.
So we finished with Kennedy.
Well, the summary in Kennedy, this is now just, as it were, amplifying it by going ad fontes. So Pittenholt is
Tab 13.
tab 13, second bundle, 404.
Just before we leave the summary in Kennedy, little 3 which you asked us to read, the Chancellor says, normally there will have to be either a mistake as to the legal character or nature of the transaction, and that's not an issue here. She intended a gift, it was a gift.
Yeah.
Or as to some matter of factual law which is basic to the transaction. Do you say that you come within that, or do you say you're an exception to that?
No, I'm saying I'm within it, because how's it different from a tax mistake, I asked rhetorically.
Yes. So you say it is basic to the transaction.
Yes.
But the case that was run by Mr. Ham was that the gift was subject to a condition. It might have been implicit, but it was conditional on there being no claim, and that was plainly rejected by the judge, and I don't think you appeal against that.
Well, I do, because it was rejected by the judge in the context of the failure of basis restitution claim. It was in that context that Mr. Ham, and he was using the word conditional as that term is used in the failure of basis authorities, which I'm going to be turning up presently.
Sorry.
So it was in that context that the judge actually understood it to be like Mr. Ham's case to be to the effect that the gift contained a condition, which would mean that there would be a resulting trust. But that wasn't the case certainly not the case that I understood Mr. Ham to be running. Mr. Humble was running a common law restitution claim in relation to the gift. So, my lords and my lady, page 404, the conscience test at H. Start paragraph 124. Lord Justice Lindley's test in Ogilvie, quoting paragraph 101 above, requires the gravity of the cause of mistake to be assessed in terms of injustice, or to use equity's cumbersome but familiar term, unconscionableness. So we're at the top of page 405 now.
Yes.
Now, importantly, he goes straight away to Mr. Justice Millett's decision in Gibbon and Mitchell, and quotes Gibbon and Mitchell. Now, Gibbon and Mitchell was a case where a settlor of a trust had surrendered various powers and interests under a mistake as to what would happen when he did that, and ended up leaving a state of affairs where all sorts of people whom he didn't want to benefit were benefiting. So it was a different type of mistake. It wasn't just a pure tax mistake, although there was a tax context to it. But it's relevant for these purposes because of what Mr. Justice Millett says in the quotation. Equity acts on the conscience. And I'd pause there to say, but what does he mean by that? The parties in whose interests it would be to oppose the setting aside of the deed are the unborn future children of Mr. Gibbon and the objects of discretionary trusts to arise on forfeiture, that is to say, his grandchildren, nephews and nieces. They are all volunteers. In my judgment, they could not conscionably insist upon their legal rights under the deed once they had become aware of the circumstances in which they had acquired them. And then he says, the evaluation of what is or would be unconscionable must be objective. Mr. Justice Millett identified precisely the class of beneficiaries in whose interest it would be for the forfeiture to stand, apart from tax considerations which would have been disadvantageous for the whole family. But he did not do so in order to embark on the impossible task of establishing the state of the consciences of minor and unborn beneficiaries. Nor, apart from a defence of change of position, not pleaded in this case, would the relative prosperity of the donor and the donees be relevant, except so far as it was part of the mistake, which it wasn't here. So, my lords and my lady, the starting point in assessing unconscionability in any case in which rescission is pleaded is to ask the question of whether or not the recipient of the property is a volunteer recipient. And then his conscience, for it is a P in this case, it's James, not Christina. It's a question for the court, is James's conscience affected now that he knows that Terrell acted pursuant to a mistake? Is his conscience affected such that he has to give the money back to her if she wants it, which she does? And that is why the focus is on the fact.
At some stage, I should deal with this. She does want the money back, but she wants the money back to defeat Christina's claims. She doesn't want the money back in her own pocket. She wants it back so that she can give it back to James later.
If she can give it back to James later. As my Lord Justice Moylan said, it may never be possible to give it back to James because of the way matrimonial law works in this.
The judge's finding was that it was going to be paid later.
Well, he said something like it would be dangerous to make the assumption or something like that. He just stopped short of making a paragraph 73, isn't it?
It's not cancelling it altogether was the words I had in mind. But anyway, don't get distracted by that.
So the start.
So it's not like a case of a donor making a gift and then saying, "Oh, if I'd realised that, I wouldn't want you to have had the money." In fact, Terrell's whole case is she does want and did want James to have the money.
That's
what she doesn't want is Christina to have the money.
But in
so
some way,
why does that? Why is it a case of Terrell being able to say, "I want the money back from James"? She doesn't really want the money back from James. What she really wants is she wants the money back from Christina. So out of Christina's hands.
She wants the money back from someone against whom Christina has a claim to the money.
Yes, but
that's the proper way to think about it.
But it's not really a case of saying, "I don't want to give this money to James." What it really is I want to arrange a way, if I can, to give the money to James so that he can keep it, not so that I can have it back. That's
But my lord, that's Pitt and Holt. I mean, your lordship will know. I mean, your lordship is obviously in Pittenholt, so I'm really nervous about addressing your lordship on this point. But as I recall the facts of Pittenholt, the facts were that the personal representatives of a deceased disabled person,
No,
who'd
not
had-
deceased. Disabled,
disabled
I think.
by the Supreme Court, it was the person.
Maybe.
Yes, I think by the Supreme Court that he was deceased, because it was but it was when he was alive, the gift was made by the receiver. Had applied to set aside, I was going to say, a trust which had been settled by his receiver whilst he was alive, on terms which basically missed an opportunity to avoid £300,000 worth of inheritance tax. And there was a very easy way to have avoided it.
There was a specific exemption in the Inheritance Tax
Quite.
Act designed for precisely that situation.
Precisely that. And they missed it, and she gave it. So the donee of the money, qua beneficiary of the trust, was exactly the person to whom, as in this case, the donor wanted to make the gift. And if she'd been able to set aside her gift at some earlier point in 1994 when the trust had been set up, she would have resettled it on the terms of the exempt provisions under the Inheritance Tax Act, which would have avoided the IHT. So that is an analogy to this case. She wants the money back because she's exposed it to a claim that for her is repugnant, in the same way that Mrs. Pitt and the other PRs wanted the money back so that it wasn't exposed to a fiscal claim which was repugnant. But nobody ever disputed that the intended donee would always have got the money one way or the other. So Pittenholt is direct authority for why the facts of this case are not outside the principle. So, my lord, but as I say, the starting point is to look at whether or not James was a volunteer. He's obviously a volunteer. He's on notice of the mistake. His conscience is affected, and he should give the money back. And my lords and my lady will also see that the relevant prosperity of the donor and donees is not relevant. The relative prosperity is not relevant. And so when my learned friends say in their skeleton argument that there was no rational consequence to the wife's mother who is, quote, immensely wealthy, that's just a submission which goes nowhere as a matter of law. And as I say, crucially, no change of position defence pleaded by James. James is not sitting on the other side of the court opposing my client's appeal. So it's exactly like the Gibbon and Mitchell facts. The persons in whose interests it would be to resist are not resisting. And so that's a powerful starting point for applying the unconscionability test. Now, what was the judge's assessment? If we go back to paragraph 81 on page 138.
Have you finished with Pittenholt?
I have finished with it for the time being, but I might come back to it, so it might be worth keeping it open.
Okay.
That's all right, my lord.
Yes, going back to paragraph.
So, paragraph 81, this is what the judge said. So he jumps straight to unconscionability. He says, I'm required to consider whether it would be unconscionable on the part of the donor to retain the property, making an assessment by way of a close examination of the facts, including the circumstances of the mistake, its consequences for the person who made the vitiated disposition. And then he says, these are the grounds that he gives. If the family court decided in pursuit of a fair outcome that it would be appropriate for the husband to have some greater obligation to the wife as a result of receiving the gift than he otherwise would have done, then it is very difficult to see why it is unconscionable for the husband to retain what remains, and it is difficult to see any rational adverse consequences for the intervener. Now, I have 4 responses to those dicta. The first is a general one, which is, just by the by, as it were, to cross it off the list. The unconscionability requirement is a requirement of equity that requires an evaluative judgment. It's not a discretion, such as like a lower court's discretion as to costs. I hope that's the point which is not in dispute. The words evaluative judgment are in Pittenholt, and if your lordships want to see them, they are in paragraph 128. But the second point is that I have set out how serious those consequences actually were to Terrell of making the gifts. It was simply wrong for the judge to find that the adverse consequences to her were, quote, not rational. Her the very money which she did not wish to expose to claims is being exposed to claims. And so the very thing which she wanted to, which but for her mistake would have been avoided, is now happening. Third, and also I should just say before moving on, this is a $34 million mistake. The sum of money is relevant. It's not by the by.
No, but the judge is envisaging a case in which some greater obligation to the wife. In other words, take the 34 million. Suppose the judge says, well, let's take 10%. Suppose 3.4 million is awarded to the wife. So there's 30.7 million retained by the husband. Isn't he addressing what's unconscionable about him keeping that? Because she did want him to have that.
Well, my lord.
Isn't that what he's saying? I'm trying to work out what the judge is saying.
Yes. It's not entirely clear what precisely has been said. But as I understand it, I think he's saying, how can it, if the wife just gets some of this money, what's so unconscionable about it being retained?
Retain what remains, is what he says. So
yes.
In my example, it's the 30.7 million. And what is unconscionable about him keeping that, because as I said earlier, it's exactly what Terrell wanted. She wanted him to have the money.
Well, my lord, that's when we come back to the taxation cases. That's when we come back to the point that the judge's finding appears to carry the implication. This is my third point. Yeah. That a mistake as to the presence of a matrimonial claim against the money is somehow distinguishable from the presence of a fiscal claim in relation to some of the money. Now, the tax in Pitt and Holt would have been payable jointly by the trustees and the donor. And the personal representatives of the late Mr. Derek Pitt, when they applied to set aside the dispositions, as the Supreme Court found it, I can show you the relevant passage, we were talking at that stage at around about £300,000 out of a total settled amount of 1.2 million is what the Supreme Court says. There's actually some other cases there, some other descriptions of it, but we'll go with the Supreme Court on this. And your Lordship can see that in the second authorities bundle at page 382. Between B and C, there was 1.2 million in damages received after the accident. And Mr. Pitt was advised that that should be settled on the terms of a special needs trust. And then in paragraph 54, if one goes down to the bottom,
yes,
it says Mr. Robert Engelhart, QC, is sitting as the deputy judge, and he observed that by 2010, the total tax, together with interest and penalties, if exacted, must have amounted to between 200,000 to 300,000. So, in any tax case, it's going to be the case that if the relief is refused, some of the money, most of the money, because we don't yet have 100% tax in the UK. Some people might think it's coming, but we most of the money, even at the highest rates of tax in 2025, will be retained by the donee. So if you follow the logic of...
You've got to be a bit careful about using a broad brush on tax cases. Pitt and Holt is one thing.
Yes.
Where what was being claimed back was the whole of the gift, the donation, because of the tax implications. In most of the tax cases, all that's being claimed back is the tax. So you're dealing with a different situation there.
My lady, you were absolutely right to pick me up on that, because the tax cases fall into two categories.
Yeah.
There are the common law restitution tax cases, like DMG, which your ladyship mentioned before. And then there are the Pitt and Holt equity type tax cases, such as the Kennedy and Kennedy case that we've looked at, Rog and Rog, which is also in the bundle, and Pitt and Holt. In the equity cases where the gift is being rescinded owing to a tax mistake, by definition, you are rescinding 100% of the gift.
Correct. That's
in the
all
restitution cases, you are saying, well, for example, if you take the...
I paid tax when I shouldn't have paid tax, because I thought I was liable to pay it, And in fact, it turned out I wasn't.
Exactly. So in Roxburgh, for example, the tobacco wholesalers sell a load of tobacco to the retailers, which carries a portion which is referable to a tax liability, which turns out to be unconstitutional, and Rothmans put it in their back pocket, and the retailers managed to get restitution. But this is a Pitt and Holt claim, and therefore you're talking about a situation where the entire gift gets rescinded, even when it's intended to go to that very donee, because the nature of the gift is infected with a mistake whose consequences it's unjust to correct, looked at from the perspective of the donor and the donee, not looked at from the perspective of Christina. She doesn't want it rescinded, of course, but from the perspective of the donor and the donee, that is what one must be looking at in relation to the equities.
Right, thank you.
So in relation to, now it's true, I should say, that in Pitt and Holt there is a famous passage, which just for your lordships and your ladyships note, is on pages 408D to E in paragraph 135, where Lord Walker observed that there might be some instances of artificial tax avoidance, even where there is no conscious risk-taking, because he puts it on two bases, where public policy would incline the court to refuse relief given tax avoidance is a social evil. But there is no sensible public policy which inhibits a mother-in-law who is minded to make a gift to her son-in-law to refrain from doing so if it attracts a matrimonial claim from her daughter. There's no sensible public policy to that effect. Now, I'm conscious of the time.
You were making 4 points, I think, and that was the. I thought that was the third. Have we got? I missed one.
Oh yes, my lord. And the fourth one, I've sort of dealt with passing, which was in relation to what was the meaning of the debate about which arose from the judge's observation, I think is the proper way to call it, that he wasn't minded to assume that the money wouldn't be given back to James at some point. And the answer is, well, as I say, hypothesise what would have happened in Pitt and Holt if Mrs. Pitt had reversed the gifts in 1994. If there had been a way of giving them on trust for her disabled husband, she would have done so, had it been possible to do so. And we can't really hypothesise beyond that. All I would say is that the allegation in my learned friend's skeleton argument in paragraph 52, that Mr. Ham conceded in closing submissions that the funds, if returned to the wife's mother, would later be given back to the husband once the wife was, quote, out of the way, is not an entirely fair picture, because if one actually turns up his oral submissions in the relevant page, which is in the second supplemental bundle at page 547, your lordships and your ladyship can see there that he is. There is a debate between the judge and the counsel. It's actually the judge's language that she is out of the way, not Mr. Ham's.
Sorry, where are we in that?
So it starts. If one takes it from just before B.
Yes.
What do you mean sort things out? They can defer. The judge says she gives it all back, and then they wait for a while. No, and then Mr. Ham says no lifetime gift. Wait for death. So that would be a will. And then the judge interrupts and says, and then when she is out of the way, you give it back again. And Mr. Ham there says yes. I don't know if Mr. Walsh was obviously there, but I don't know whether he's just saying yes to be polite to the judge, or whether, because he said no lifetime gift 2 lines earlier, but there wasn't any firm suggestion that there would definitely be an inter vivos gift. I mean, if the matrimonial lawyer, this notional matrimonial lawyer that the Lord Justice Moylan posited earlier, were to say to her, there is no way of you making an inter vivos gift now to James without Christina touching it, that is obviously something that she is going to have to consider very, very carefully. And as I say, Mr. Ham's suggestion that there might be a testamentary gift suggests that there may never be an inter vivos gift. The key point is that to make a testamentary gift, she needs it all back, and that's what she wants, and James isn't resisting that. Now, clean hands, my lords and my lady, I need to deal with this briefly. This is another one of my learned friend's new points. not supported by a respondent's notice, not taken below, no authorities, no submissions about it, never mentioned anywhere in the judgment, but they want to rely on it in the Court of Appeal. Now, some preliminary... So to set this point up, if your Lordship is against me, that this point should simply not be entertained, because it is a proper point of law which wasn't taken, and it would have required different cross-examination. My learned friend's argument rests on the contention that because Terrell was one of the family witnesses, as the judge called them, who coordinated their stories to help the case, that there was no failure in the husband's disclosure, the judge must have been influenced by that in dismissing the mistake case. But in fact, we've just looked at paragraph 82 of the judgment. Sorry, paragraph 81 on page 138. There is no reference whatsoever in that paragraph to the dismissal of Terrell's evidence, which was given in support of James's case in relation to the disclosure issue. And what I must do is deal with the authority that my learned friends rely on in this regard, which is the case of Royal Bank of Scotland and Highland Financial. So Royal Bank of Scotland and Highland Financial is at, in the first authorities bundle under tab 12 at page 339. That's the relevant, famous passage. I'm going to just show your Lordships and your Ladyship the famous passage, and then I'm going to explain the factual distinctions between that case and this one. So the famous passage says, it was common ground...
Sorry, wait a minute, which page?
I apologise. 339.
Thank you.
Paragraph 159, between E and H.
Yes.
It was common ground that the scope of the application of the unclean hand doctrine is limited. To paraphrase the words of Lord Chief Baron Eyre in Dering and Earl of Winchelsea, the misconduct or impropriety of the claimant must have an immediate and necessary relation to the equity sued for. The limitation has been expressed in different ways over the years in cases in textbooks, recently in Fiona Trust by Mr. Justice Andrew Smith, which he noted that there are some authorities in which the court regarded attempts to mislead it as presenting good grounds for refusing equitable relief, not only where the purpose is to create a false case, but also where it is to bolster the truth of fabricated evidence. But the cases noted by him were ones where the misconduct was by way of deception in the course of the very litigation. It's going to be important to consider what that word actually means. Directed to securing the equitable relief. And then there's a reference to Spry, which suggests that it must be shown that the claimant is seeking to derive advantage from his dishonest conduct in so direct a manner that it is considered to be unjust to grant him relief. Ultimately, in each case, it's a matter of assessment by the judge, who has to examine all the relevant factors in the case before him to see if the misconduct of the claimant is sufficient to warrant a refusal of the relief sought. Now, the facts of this case were very shocking in some regards. It involved a series of transactions undertaken by RBS, whereby, in essence, they shifted some assets which were securitized onto their own balance sheet. And they tried to resist the claims of their counterparty in this regard by putting forward, or at least they called a witness who was one of their personnel, described as SG in the judgment, who gave completely false evidence about the transactions in question. And then eventually the Court of Appeal actually set aside the liability judgment and the quantum judgment on fraudulent grounds. But the significance of what happened in that case for these purposes is that Highland and another one of the respondents decided to issue proceedings in Texas which effectively raised exactly the same allegations against RBS as had been raised in London. And RBS said, well, there's an exclusive jurisdiction clause, this is a London matter, it's all in London, there should be an anti-suit injunction to stop the proceedings in Texas. And there's an illuminating passage, my lords and my lady, at paragraph 167 between F and H on page 341. where Lord Justice Aiken says the misconduct is immediately secondly, that misconduct, i.e. the misconduct which he has found, is immediately or closely related to the equity sued for because it relates, at least in part, to the very allegations being made against RBS and its witness in the Texas proceedings under count 2 of that petition. The aim of the anti-suit injunction is to prevent Highland and another respondent pursuing those allegations in the Texas proceedings because it is said they have agreed that all such matters would be dealt with exclusively by the English courts, or in Scott Law's case, were bound by that agreement. The judge has found that RBS, through its witness, SG, has lied about central facts on which Highland and Scott Law found the allegations that are made against RBS in the Texas proceedings. RBS through SG has relied on this false evidence in the course of the English proceedings, whose very object is to stop the Texas action. To my mind, the misconduct could not be more immediately related to the equity that is sued for. Now, contrast that situation with this one. The aspects of Terrell's evidence, which form part of the judge's compendious rejection of the family witness's evidence, had nothing to do with the equity she sued for. Indeed, and this is recorded by the judge, importantly, on page 134 of the judgment in paragraph 70, that Mr. Ham raised his arguments in the event that I am minded to allow the wife set-aside application. And indeed, as a matter of, it couldn't be more vividly demonstrated by the fact that Terrell gave 2 witness statements. She gave one in July 2023 in respect of the set-aside application, and she gave a separate one in August 2023 in respect of a claim in equity. So in other words, this claim arose in the event that the set-aside application had succeeded, and none of the ingredients of the mistake case that I put before the court, what the consequences are to her, what her mistake was, and so on, required her to rely on any of the evidence which she gave, which the court rejected. Now, if you contrast that with the RBS case, the matters, the counterparties had issued proceedings in Texas to litigate the very matters in relation to which RBS had been found through its witness to have given false evidence in England. And then RBS turned around and said, well, you can't have your Texas proceedings because we're entitled to an anti-suit injunction. There was a complete jigsaw match there between the equity sued for, i.e. the anti-suit injunction, and the dishonest evidence. And that you just don't have, it's just not quite the same in this case at all. But as I say, the clean hands point, and that is why, I should conclude by saying, the judge was absolutely right not to mention any of those matters in his disposal of the state case in paragraph 82. First of all, he wasn't asked to, and secondly, it would have been wrong for him to do so. So, my lords, my lady, failure of basis. That is my case on Pitt and Holt. I don't know whether your lordships have any further, or my lady has any further questions.
I think so, thank you.
So, in relation to failure of basis, now, one thing that I've got to make clear at the very start is that wholly different considerations apply to this. This is a common law restitution claim. Questions of unconscionability, what people said in the witness box and so on, they just don't come into it. If the cause of action is made out, subject to a change of position defence which has not been pleaded, James must make restitution. But it's a personal liability, not a proprietary liability, and that may well justify a lower test. Now, it was said when my Lord Justice Nugee gave my client leave to appeal that there were some immediate problems with this case, essentially. One of them was that if the gift is voidable for mistake under ground 1, ground 2 is superfluous. And if the gift is not voidable for mistake, it stands as a gift. And that seems to me to justify the Doney keeping it, or if one prefers, would mean that there was no failure of basis, as the basis is the gift. Now, I know I need to address the question, which is a huge question of law to some degree, as to whether or not a gift is a so-called justifying factor for the purposes of the law of restitution. I'm not going to shrink from that, which is why I want to keep up the pace, because I know that is a big point. But before I get to that point, logically I need to develop my case in relation to whether there is a restitution claim here at all. Now, questions of mistake and misprediction don't come into this at all. Just for your lordships and your ladyships note, I don't have time to turn it up, but in the fourth authorities bundle under tab 39, page 1309, para 9-15, Goff and Jones make it absolutely clear that even if there is no mistake and merely a misprediction, you can still have a claim in failure of basis. So even if your lordships and ladyships are with my learned friends on that point, which you should not be in my humble submission, that does not defeat a failure of basis claim. I want to begin by taking up the leading authority in England, which is Degamo Holdings, which is in your third authorities bundle, under tab 26, page 904.
Can you say that again, please?
The third authorities bundle,
Yeah.
tab 26, page 904.
Thank you.
So let us start. I mean, I don't want to start, as it were, too elementarily, but we might as well start with paragraph 55 on page, paragraph 55 on page 904 of the authorities bundle. And this just goes to my point. This is a simple common law cause of action. Has the defendant been enriched? Yes. Was the enrichment at the claimant's expense? Yes. Was the enrichment unjust? Well, that's the failure of basis point. And fourth, are there any defences? None that James has pleaded.
Sorry, I got lost. Which page?
904, paragraph 55. So the issue between the parties, and it also, I suppose, logically embraces the point raised by my lord when granting us leave to appeal, is the third issue. Was the enrichment unjust? But that is not a discretionary factor. If one is able to make out a recognised unjust factor, then the relief subject to defences must be granted. And then at 57, we have to positively identify what has been described as the unjust factor. And then if one goes on to page 909, paragraph 77, we get into the substance of it. So the court begins by rejecting the label of failure of consideration, because it doesn't just relate to consideration. 79, between E and F, the core concept of failure of basis is that a benefit has been conferred on a joint understanding that the recipient's right to retain it is conditional. If the condition is not fulfilled, the recipient must return the benefit. Whilst failure of basis ranks alongside the other unjust factors as a factor negative in consent, it differs in that it is concerned with qualification of consent as opposed to impaired or vitiated consent. Para 80, it is common ground that the meaning of failure of basis extends beyond failure of promissory consideration, payable under a contract, or a failure of contractual counter-performance. And then Professor Burks is quoted, I believe he is, yes, failure of consideration, as this concept used to be called, for payment, means that the state of affairs contemplated as the basis or reason for the payment has failed to materialise, or if it did exist, has failed to sustain itself. And then there's reference to a case that has come up in questions from the bench, emanating from my lady. There's reference then to the High Court of Australia's decision in Roxburgh, and it's clear that Roxburgh here is being followed. It's also, if your lordships and ladies are interested, being followed in a Supreme Court case called Barnes. So Roxburgh was a decision of the High Court of Australia, and then at 83 you have the facts. We've already mentioned them. Tobacco retailers, tobacco wholesalers charge tobacco retailers a sum of money for the tobacco, which carries a portion referable to a duty. And then if one carries on, one sees that It's described as a licence fee. Over the page, the licence fee was held subsequently to be a duty of excise, and essentially it was invalid. But the sums of money were retained by Rothmans rather than being given back to the transferees, to their customers. And then at 87, Your Lordships and Ladyship see that the majority held that there had been a failure of a distinct and severable part of the consideration for the purchase of the goods, and that there was a total failure of that consideration. So the contract remained valid, and I'm going to come back to that point in answer to my learned Lord Justice Nugee's question. There was no need to vitiate the contract. The amount claimed was recoverable as money had been received to Roxburgh's use. That was so notwithstanding that when Roxburgh sold goods to its customers, it had charged prices which covered the cost of the amount that they sought to recover from Rothmans. And then at 89, the majority accepted that failure of basis embraces payment for a purpose which has failed, as for example where a condition has not been fulfilled or a contemplated statement of affairs has disappeared. So the conditionality embraces, for these purposes, a contemplated state of affairs having disappeared. The basis in this case was the common intention of the parties and the revenue authorities. The cost of the goods would include the licence fees, and those licence fees, when so incurred, would be paid to the revenue authorities by Rothmans. In the events that happened, the anticipated licence fees were not incurred by Rothmans, and that state of affairs effectively was altered. Now, if one goes forward in the judgment up to page 916, there's another passage I just want to show you. It's made this point now twice, but I'll make it a third time. Paragraph 102, it is well established that failure of basis must be total. Hang on, that is not... yes, sorry, I apologise. It is 960, I'm on the wrong page. Paragraph 106. The central question is whether or not the judge was wrong to reject the unjust enrichment claim on the basis that the necessary alleged unjust factor, namely failure of basis, was not made out. As set out above, this is to be determined not by reference to general and subjective notions of fairness or justice, but rather by reference to an application of the relevant principles of law to the facts in the search for an unjust factor. So very much common law. Now, turning to the facts of our case, what do we know? We know that these gifts, the payment of these gifts, to be precise in my language, picking up Lord Justice Moylan's comments, the payment of these gifts was not made twice in July 2021 and March 2022. But we know that it was made in July 2022 when, as the judge put it, it was thought that the coast was clear. So what can be inferred from those basic facts, particularly if one were to adopt my learned friend's reading of the events of March 2022, which obviously I don't for the purposes of my mistake case, and I don't need to for the purposes of this case, because there's enough common intention between those three events. What we know is that the payments would not have been made when there was a perceived risk of claims by the wife, and they were only made when it was perceived that there would not be a claim. So when you match those facts to the principle, there was unquestionably a common understanding between donor and donee upon which the gifts were premised that the wife would have no claims to them, could have no claims to them. They were not made when it was thought she could have done, and they were made when it was thought she couldn't. And that basis has failed. And what the common law says is, of course, James, if he wants, can plead a change of position defence, but he hasn't. So he has got to make restitution, account for the monies hadn't received in the old language, for the whole sum. That's the case. Now, the reasons why the judge rejected it were Well, in neither case correct, if I may respectfully say so. So if one goes to 138, I apologise, it's further up, 136. I mean, I apologise, it's 134.
Yes.
So in paragraph, actually he starts off by setting out a letter that was written on the 5th of July on 134, and then he goes to 135, and then one gets over to 135, and he says, on the face of it, there is no sense here of any condition on the gift. The money once given is the husband's to do as he wishes. So what the judge appears to have done mistakenly is to treat the letter of the 5th of July as akin to an instrument of gift, which it obviously was not. And it wasn't even written at the time of the gift. It's clear.
Fair? He's simply looking at it as contemporaneous evidence of the party's intentions.
That's correct, but the issue, I think where the confusion comes from, m'lady, is that the judge appears to be looking for what might be akin to a contractual term of the gift.
That's surprising, because as I understand Mr. Ham put it to him on the basis it's a Marks and Spencer implied term type.
I'm not sure that is entirely fair. I mean, there's some redaction in the quotation in the judgment. We can go back and have a look. But as I understood what Mr. Ham was saying, he was basically saying it's like a mark. There doesn't need to be an explicit agreement between the donor and the donee.
If you look at 76, where he quotes from what I assume are the closing submissions,
Yeah.
she made the gifts to James on the implied condition. And that's how you get into Marks and Spencer.
Yes.
That if you go over the page, a term can be implied where it's so obvious without saying. So that's obviously in a contract, and he's saying it's analogous.
He's saying this.
So isn't it fair for the judge to say, well, here's the letter which explains the gift, and there's nothing there.
There's nothing in that letter. There's no express term in that letter.
There's no express term and no reason to imply one, he goes on to say.
Well, except that the word condition, as I've shown your lordship in the judgment from Dargamo, is used interchangeably with the idea of a shared understanding upon which the transaction is premised. And I accept my learned friend's objection up to a point that if there is no condition, no failure of basis. But one has to understand the use of the word condition in the authorities, a shared understanding upon which the transaction is premised. And the question which the pivotal question which the judge should have asked himself was as follows. Was it discernible objectively from the whole of the parties' dealings, including from the donor's refusal to make and the donee's refusal to accept the gifts prior to the conclusion of the divorce, that there was a shared basis or shared understanding on which the gifts were premised to the effect that Christina must not be able to make a claim to them? Now that is the correct question which the judge should have asked himself on the basis of the authority to which I've just taken the court. And if the answer to that question is yes, then one switches to ask whether there was a defence pleaded by way of change of position, and there was not. And if there is not, then there is restitution. And that is...
There was no defence pleaded by James at all.
No.
And the claim was only against James.
Correct.
Why didn't you get judgment on admissions?
Well, I understand that there was a strikeout application. Yes, the judge directed points of claim, so it wasn't like it would be in a normal civil action where you could get judgment under the CPR on admissions, as I understand it.
But it is something that's been troubling me, is that if James wants to give the money back, he can give the money back. He can submit to judgment. It probably won't have any effect on Christina's claim against him, because she's entitled to say, this is a resource that's available to you, you've given it away. But as far as he's concerned, why doesn't he just give the money back?
Well, that's a question, my lord, that you'll have to ask Mr. Todd. My client is maintaining a claim against him to give the money back.
Yes, I see.
And there it is. I mean, as your lordship makes an interesting
it might
point.
be thought to be a transaction to defeat a claim. So
Well, it
it
might
might
be,
lead to an
yes.
application for an injunction.
That's a
to,
good point. Under Section 37.
yeah, and indeed it would be assumed to be a transaction to defeat a claim because it's within 3
So
years.
that in effect, the wife can prevent the claim from succeeding. Is that right?
No.
She can argue, as she does, that the claim shouldn't succeed. She has an interest in that.
Yeah, but she can't argue change of position. It's only James. It's only James who can argue that, and she hasn't.
She hasn't.
So nobody's argued change of position.
Yes.
The only
I
question
see.
is whether if that pivotal question, which I can repeat it again, is answered in the affirmative, and it's very difficult not to answer it in the affirmative in my submission.
Could you repeat it?
Was it discernible objectively from the whole of the parties' dealings, including from the donor's refusal to make and the donor's refusal to accept gifts prior to the conclusion of the divorce, that there was a shared basis or shared understanding on which the gifts were premised, to the effect that Christina must not be able to make a claim to these gifts? And there obviously was.
Does not be able to make a claim or not be able to get her hands on it? We're back to the same old, aren't we? The shift in position is important because it seems to me that if you can't make out the mistake, you can't make out a restitutionary claim.
Actually, my lady, that's not strictly speaking correct, if I may humbly say so, because, as your ladyship's, failure of basis does not require a distinct mistake as at the time.
I know that.
So if,
But I'm looking at the facts of this particular case and the nature of the mistake that you are alleging, which has, from time to time, metamorphosed, not meaning to be pejorative about it, but the question is, was there a common understanding that Christina wouldn't be able to get her hands on the money, or was there a common understanding that Christina would not be able to make a claim to the money? And I think it makes a difference.
Well, it is.
I know the way you put it on the mistake is that she wouldn't be able to make a claim to the money.
Yes. And that must be the common understanding as well for the purposes of failure of basis. But if I'm wrong about that, it doesn't matter because misprediction can be a basis upon which a transaction fails. So if it was a case of predicting whether or not she would actually bring a claim or actually get her hands on the money, then that can still be the shared basis or understanding for the purposes of misprediction, for the purposes of failure of basis. What matters is whether or not the basis has failed.
What matters is whether or not it was James's understanding that if Christina made a claim against him, he'd have to give the money back. Which he hasn't done.
Well, why? I don't, my lady. I'm not sure that one does need to prove that he would have to understand that if a restitutionary claim was made against him,
he'd have to understand he wasn't entitled to keep the money because the whole basis on which it was given to him has failed. That's what this type of restitutionary claim is about. It's about undermining the very bricks and mortar of the bargain that's made between the parties, whether it's a binding contract or in this case a gift. I have quite a lot of conceptual difficulty, I have to say, with the idea that a gift can be defeated in relation to this type of claim, but leaving that conceptual difficulty aside, because a gift is usually an outright gift. It's a gift. I'm giving money to you, and there's no conditions attached to it.
Well, yes, my lady, can I just deal briefly with that point, just by the by, if I may? Gifts are made subject to conditions all the time. I mean, the law of perpetuities is all about gifts which are made subject to conditions which may not be fulfilled until too remote a time. So the fact that a condition external to the outright nature of the gift exists does not mean that it's not a gift. It just means that it's conditional. But that's a separate point. I think the judge was confused probably an unfair word, but he was taken by the point that it was an outright gift. The fact that it was an outright gift is irrelevant. If there was an external condition attached to it.
But when he says outright, I think what he means is not subject to conditions, isn't it? I mean, that's what he means by outright.
Yes, and that may be correct, my lord. But the
So I understand that you can make a conditional gift.
yes, of course.
I'll give you £100, but this is conditional on you passing your exams,
Yeah.
or whatever. Those are very simple, but the conditions are usually expressed. Now, obviously, they can be implied, but your analysis of the Roxburgh case is that this is a different failure of basis is wider than that, and that when condition is used in explaining what failure of basis is, it's not a sort of narrow condition precedent or condition subsequent, as in the law of perpetuities or whatever.
Yes.
It is a shared understanding.
Shared understanding upon which the transaction is premised, yes.
But then that goes back to my latest point, that is it your case that James understood that if Christina made a claim, he'd have to give the 34 million back? And if it is, what's the factual finding, which is the basis for it?
You've been asked a question. It's
Absolutely.
1 o'clock. I'm going to stop there. Will 10 minutes afterwards be sufficient for you to finish your submissions, including answering that question?
Including answering that question and also answering the googly that was bowled to me in the leave to appeal order, which by my Lord will just, and also answering a similar question from my lady. Are gifts within this?
Okay, so you'll be 10 minutes.
10 to
right?
15 minutes.
Okay.
I'll do my best.
Thank you. And Mr. Are you both making submissions, or
Just me, my lord.
just you? Okay. Will that leave you enough time?
It will, my lord.
Thank you. Thank you.
And for a reply, my Lord, as well.
Of course.
Court rise and table.